Hello, everyone. Thanks for joining us today. Before we get started, I just wanted to let you know that we have a completely optional survey for you. This is simply to help us better understand who is joining us today and from where. If you feel comfortable sharing, please use the link we've shared in the chat and answer a quick couple of questions. You'll also have another chance to answer at the end of the webinar. A new window will pop up with the survey automatically for you. I'll also note that we will be sharing a few different links in the chat today. And apologies for my 8-month-old work partner in the background. So keep an eye on the chat for the multiple links that we share. Today's webinar is hosted by John Salois, the Law Center's Youth Shelter and Housing Attorney. I'm so sorry. And the author of the practice guide that you will receive a little bit later in today's presentation. Joining John in discussion is Tori Dempsey, the Youth and Advocacy Program Director at the Legal Services of Eastern Missouri. Thank you all for being here. And John, the floor is yours.
Thank you, everyone. Thanks for showing up, especially Ren. Thanks, Ren. So good afternoon, everyone. Thanks for joining again. This is a webinar regarding the due process rights of youth in shelter. We'll be presenting a lot of information here this morning. So if you have any questions, you can put them in the chat and we'll follow up with you. Or if there's time at the end of the webinar, we're going to try and answer them then. So rest assured, we will follow up with you. It just might not be during the webinar. Could be after. So again, the issue I've been researching for the past few months is what are the due process rights of youth in shelter and other housing. And when we say other housing, we mean emergency shelters for youth and young adults. We mean transitional living programs, maternity group home programs for parenting youth, programs for youth aging out of foster care, host homes, supervised apartments, really any and all housing programs that youth encounter when they're experiencing homelessness. So just a little bit about me first. So I'm John Salois again, the Youth Shelter and Housing Attorney at the National Homelessness Law Center. I've been practicing for about 15 plus years. Emphasis probably on the plus these days, but in most of that time I've worked with youth experiencing homelessness. I co-founded and ran a small nonprofit in Portland, Oregon, around the legal rights of youth. It was called the Homeless Youth Law Clinic. And I also worked in Seattle at the Legal Counsel for Youth and Children, which is a model program at the Homeless Youth Law Network. And that's when I came to the National Homelessness Law Center. I've been here for about a year. So I'm going to pass it to my co-presenter today, just to introduce yourself, and then we're going to get started.
Hi, folks. Thanks for joining us. My name is Tori Dempsey. Thank you, John, for the introduction. I am the Program Director and Staff Attorney with Legal Services of Eastern Missouri's Youth and Family Advocacy Program. Just kind of a little brief overview about what we do with our program so you can kind of get a better idea about what I do in my day-to-day professional life. So I specifically provide free civil legal assistance to unaccompanied youth and young adults who are experiencing homelessness. So they're not living with a parent or legal guardian, and they are experiencing some sort of housing instability or are at risk of becoming homelessness. So myself, along with my amazing team, including our social worker, Kristen Young, provides support to young adults in our area, which can range from ID access to shelter access, housing program access, which we're going to go ahead and cover today, public benefits, really the whole gamut. So I'm really excited to be here today to talk with folks about the due process rights of young people. It's so incredibly important, and it's really encouraging to see such a wonderful turnout. So thank you.
Thanks, Tori. Appreciate it. I'm so happy you actually joined us today. Sometimes Tori and I think we're the only people talking about this issue, so it's really nice to see people show up and just to be interested in the issue. So what I thought it'd be interesting to do at first. So I think about this issue quite a bit. So when I think about the due process rights of youth, I know what that means, but we're wondering if you knew what that means. So we are wondering if you could take yet another poll, but I think it's going to be in the chat. But we are wondering, when we say the due process rights of youth, do you know what that means? Does that mean a right to a hearing? Does it mean right to appeal a decision if removed from shelter? Does it mean a notice of termination or right of appeal? Or does it mean all of the above? So it just popped up on our screen. So anyways, while you fill that out, I'm gonna move on and talk and start the presentation. So I became interested in this issue a couple of years ago. It was a case I encountered while I was practicing. So when you represent youth, you come in contact with youth all the time, right? And you come in contact with youth sheltering in, cycling in and out of shelter. Sometimes they're exited, sometimes they could be even banned from shelter, sometimes they just get lost in the shuffle. So this is a very common issue. But I met this youth that I think it showed me that there can be dramatic consequences for youth who are terminated from shelter. And it really, more to the point, is there are protections for youth that maybe some of us don't know. So I met this person. Her name was Aaliyah. I'm going to call her Aaliyah. I met her. She was 20 at the time when I met her. She started when she began experiencing homelessness. She went into emergency shelter. Then she moved into transitional living program really quickly. And when I met her, she was actually in an apartment. She was in an apartment, and she had a grant from the same service provider that she had been receiving services from. And she was in this apartment with her boyfriend, who was also a client of the service provider. And then they also had a young baby. And they were doing well. They both had jobs. They were struggling, but they were stabilized. But so one day, her case manager wanted to come visit her and bring her something. I think it was actually something for the baby. So my client, Aaliyah, she was running late. So she called the case manager and told her she's running late. She can't be there today. And so if that would be okay. So shortly thereafter, she overheard her case manager tell her friend that Aaliyah was irresponsible, always late, and that she needed to act right. So Aaliyah was obviously angry. So her and her boyfriend, her partner, they confronted the case manager and asked her to apologize. The case manager actually refused and then hung up on her, and she threatened to cancel her grant. So, and then shortly thereafter, shortly thereafter, they began receiving threatening text from an unknown number. And then even shortly after that, someone visited them at their place of employment and threatened them. So this was pretty alarming stuff for them. And so if I was advising them at the time, I would have told them exactly what to do to meet with the executive director and the case manager to try and resolve the issues, which is exactly what they did. But what happened was, at the meeting, the executive director and case manager, they were all there with her boyfriend, and they basically said, you did something wrong, Aaliyah, you did something wrong, case manager did something wrong. So let's just forget it. But oh, by the way, we don't want to work with you anymore. Your grant is canceled permanently. So it was pretty alarming for them. They didn't really know what to do. They actually wanted to file a restraining order, but they were nervous about retaliation. So eventually they got to an attorney, which was me. And actually didn't know what to do, quite frankly, when this issue was, came to my attention. But what we ended up doing was we filed a complaint with the state agency who funded them. And eventually the agency sanctioned the service provider for violating their confidentiality. And then they actually also got her a separate grant from another service provider. We actually helped her access funds to help pay her rent that had been in arrears. So we got her to a place. It took months and months, though. It was really traumatic for her. The prospect of becoming homeless again with a baby was really sort of heart-wrenching to her. And she didn't really understand how this could happen, and if this was actually happening to a lot of people. So as an attorney, it was an eye-opening experience for me, because it's, a system that's designed to assist Aaliyah ended up causing her more harm. And there didn't appear to be a fair process to complain or challenge the behavior. So it was eye-opening for me. But what I didn't know at the time is that there are rights attached. Something actually Tori knows better than I do. She's much more in tune with it than I was, because there are rights attached, and that's what we're going to talk about today. So the first thing I want to talk about is, what is due process? We're going to just have a little short tutorial on what due process is. So the notion of, and there obviously there are two kinds of due process. There's substantive due process and procedural due process. We're talking about procedural due process. So the notion of procedural due process derives from the U.S. Constitution, from the 5th and 14th Amendments. Both amendments guarantee due process when a person is denied life, liberty, or property. So that doesn't mean that the government can't take away your rights or a person's life, liberty, or property, but it can't take those things away without first giving that person a fair chance to defend themselves. So for instance, the government can't imprison someone or take someone's children from them without the person being able to challenge the government's actions. So this also applies to property. So in something a lot of people call entitlements, our government, we pass federal statutes to give entitlements to folks, like such as something, Social Security or temporary assistance to needy families, or even something that I think is a really good corollary when we talk about this is a right to a public school education. So when a student is suspended from school or expelled, before that can happen, the person is entitled to notice the suspension, a right to be heard on the suspension, and an unbiased decision maker to decide. So to sum up, depending upon the nature of the benefit, more or less of the process is due. But at the very least, it must include notice, an opportunity to be heard, and an unbiased decision maker. And there is a difference too. I don't want to get into too much of the weeds here, but there's pre-termination hearings and post-termination hearings. What we're talking about is a pre-termination hearing. Before someone can be sent to the street, and if they're in a shelter or in their housing program, before they can be sent to the street, there must be some kind of process. So now I'm going to talk about some legislation. There's two pieces of legislation we're going to talk about. But the first big piece of legislation is something called the Hearth Act. So the Hearth Act transformed how we funded homeless services in this country. It's really the biggest piece of legislation on homelessness. What it stands for is the Homeless Emergency Assistance and Rapid Transition to Housing Act, so HARTH. It was passed in 2009. It was a reauthorization of the McKinney-Vento Homeless Assistance Act, and it had substantial changes. It did a lot of different things. But for our purposes, we're just going to talk about youth here. But this is a huge piece of legislation. But what it did for our purposes today, it consolidated HUD's competitive grants programs, and it made two massive pots of funding. So the Continuum of Care funds, which is more of a community-wide way to solve homelessness, and then there's the Emergency Solutions Grants programs, which it's more of your standard emergency shelter, transitional living programs, rapid rehousing, those types. And so this is monies that grantees and people can apply for to get these monies. And the law, it was changed. It was to streamline access to housing and rapidly housing people. That was the new goal of the law. And it did a lot of other different things, but one thing it did, it changed HUD's definition of homelessness and chronic homelessness. And that had a couple of different effects for youth. So it did two things when it changed the definitions here. So one, as it pertains to youth, it redefined what age youth are under the Act to include youth up to the age of 25. It was HUD's goal to adequately address the unique needs of transition age youth by redefining the definition of youth, including youth exiting foster care systems to permanent housing. So this was the goal. It was because if anybody knows anything about youth homelessness, the foster care system is a big feeder of youth homelessness. Some of the stats are 40% of youth within 1 year of leaving foster care will be homeless. So this was a goal of HUD to try to address that problem. And it did one other thing. As it pertains to youth, did a lot of other things, but just for youth. It said unaccompanied youth under 25 years of age, or families with children who youth do not otherwise qualify as homeless under this definition, as long as they qualify under another federal statute. So even if they're not eligible under Continuum of Care funds or Emergency Solution Grants funds or this Hearth Act, as long as they qualify, say, under like the McKinney-Vento Act, VAWA, Head Start, because those are much more liberal definitions of homelessness. So as long as they qualify under those definitions, then you're eligible under these funds, and you can access these funds. So, and then there are a few other criteria that they must have met, like you can't have had a lease for 60 days. You have to have had persistent instability. But suffice it to say, if you qualify under, say, McKinney-Vento, which is a really big one, Tori will tell you of educate the youth in education. There's a lot of need there, and a lot of people who are covered. So, so all that to say that, so this was passed in 2009, and then there were federal regulations to implement the statute in 2011 and 2012, and which covered what is due process. And in the regs, they actually don't use the word due process as much, because it's really just a modicum of due process. They use termination of assistance to participants is how they use it. So I'm going to talk about ESG grants first, the Emergency Solutions Grants Program, and then the COC grants. They're substantially similar, but there is a really big difference, actually. So in general, if a program participant or a youth violates program requirements, the service provider may terminate the assistance in accordance with the formal process established by the service provider that recognizes the rights of the individual. Service provider must exercise judgment and examine all extenuating circumstances in determining when violations warrant termination, so that the youth is terminated only in the most severe cases. So you must take those two things into account, only in the most severe cases and all the extenuating circumstances. And then you must also give the three requirements. So to terminate rental assistance and housing, you must give written notice to the program, written notice to the youth containing a clear statement of the reasons for termination, a review of the decision in which the youth is given the opportunity to present written or oral objections before a person other than who approved this decision, or even a supervisee of that person. You must also give prompt written notice of the final decision to the youth. And it must also include ability to provide further assistance. So you can't, if a termination is successful, you just can't ban someone from having assistance. They can get back in line after a limited amount of time. So those are the emergency solutions grants. That's what it says about terminating assistance. So I'm going to move on to the continuum of care regulations, which, as I said, they're substantially similar. They use a lot of the same language around extenuating circumstances and only in the most severe cases. But there's one big difference in the notice provision. So it has all those three requirements, but initially you must provide the youth or the program participant a written copy of the program rules and the termination process before the youth begins to receive assistance. So if you did not give someone all the policy and procedures when they entered the program, then you did not meet the notice provision. So those are the differences. That must be written notice to the program participant and review of the decision, same things, but that initial notice provision is different. So I'm going to pass to Tori now, who's going to talk about something we're calling notes in the field, and she's going to talk about what she's seeing.
Thanks for that wonderful overview, John. I know these regulations and all this information can maybe feel a little bit overwhelming and really complex. So I'm hoping to be here to kind of provide folks with some real-world examples of how this implicates young people, service providers, and give some more context in what I do in our program when we're confronted with the termination of a young program from one of these housing programs that are supported with ESG or COC funding. I'm just going to preface this with, I'm sure we have a lot of folks that are service providers on this call today, maybe practicing legal professionals. The way that I always approach my work is I am always about giving information. We want to prevent any terminations from happening that aren't compliant with the law. So my approach is always education, education, education. So when I said I'm really encouraged that people are here today, it means that you want to learn more and you want to improve your program. So I'm just going to go ahead and give a case example. So I was working with a client who was residing in a transitional living program supported with COC funding. I know John will get to this at the end of the presentation, but I'm just going to kind of just mention it here now. So when you're working with a young person that notifies you that they're getting terminated from housing, my first step is always to figure out what source of funding is supplying that housing. So a lot of times COC and ESG funds or grant awards are made public information, so I can easily find that information. That helps direct me to where in the regulations am I going to? What other laws apply to this particular housing program? So with this particular young person, they were already an existing client of mine. They contacted us one day letting us know that they were told by their case manager at their housing program that they were being terminated and that they had to be out in 30 days. So for me, I work very closely with our social worker. She is absolutely amazing. She was instantly alerted, there's a legal issue here. I need to wrap in the attorney so we can get more information. And so for me, in addressing a problem like that, I knew that this particular housing program was supported with COC funding. So I go straight to the regulation that John just put on the screen before now. And I just went through the requirements with my client. Number one, were you provided any information about the program rules before you were accepted into the program or upon being accepted to the program, and what their termination procedure looked like? In this particular instance, my client reported that no, she had not been provided with their explicit termination procedure. She was provided with information about program rules and what was going to be required of her, but other than that, no clear termination procedure had ever been provided to her. Moved on to second, were you provided with any written notice, something in writing, a piece of paper notifying you that they were going to seek to terminate you from the program and give you an explicit reason with particularity why they were terminating you from the program? In this instance, this young adult was only told verbally that she was being terminated from the program. Her particular situation, for just a little bit more information, as I believe her case is pretty indicative of other cases that I've encountered as well. You have young people in housing, they've experienced a lot of trauma. Emotions are high, there's a lot of anxiety, and for this particular young person, she had had several other encounters with staff where things got a little elevated. There was some exchange of words, but nothing ever got physical. She would always just kind of separate herself from the situation. On one particular day, she came home after a very long day and had a verbal confrontation with one of the staff persons. She left the situation, went to her apartment. The next day, staff knocked on her door, let her know, we're having a meeting right now to discuss last night. She went to that meeting, was not really provided with much notice, and was informed at that meeting that they would be terminating her effective 30 days. So as I'm going through these requirements, it's clear that she wasn't provided with any sort of written notice, letting her know the specific grounds for her termination. She wasn't provided a real opportunity to review that decision because the meeting was there to essentially already notify her that they made a decision to terminate her from the program. So there wasn't any opportunity for her to, one, know in advance what this meeting was about, when any sort of genuine advance what this meeting was about, and to a real opportunity to defend herself and kind of plead her case, or even contact me for my assistance, or contact a social worker or another trusted adult to help facilitate and hopefully come to a resolution other than becoming homeless yet again. And then after that meeting, I mean, she was told verbally in that meeting that she would be terminated and was never provided any sort of written notice of the termination, and only told that she had the 30 days, which can be problematic for a lot of different reasons. One is if you don't have anything in writing, it makes it very easy for people to change the deadline or shift the reasons for why this young person might be terminated from a program. So it's really important that you have things in writing so you know exactly what it is that conversation is going to be about. With every client that I encounter, when she felt very emotional in the moment, but based on her previous experience at this particular housing program, it was her decision that she was no longer interested in remaining in the program. And when I gave her options, I can contact the housing provider, let them know that they're required to go through this particular process before terminating you from the program. We can fight this. She was not interested in that because she was not interested in remaining in the program. The second option that I gave her is, well, and the other thing I'll say with that as well is that she was also worried about retaliations. And she would be looking for new housing in the preceding 30 days. She would have to stay at that particular unit. And she was worried that the environment would become more hostile if I got involved while she was still there and interacting with staff on a day-to-day basis. So the option that I gave her then is, and it's always client choice, after you leave, we can assist you, with finding a new place and getting you rehoused. But after you leave, the other option is I can reach out to them at that point and address the issue with them, because chances are, if this is the way in which they handled your particular termination, this is probably the way in which they've handled previous terminations and future terminations. And so we came to an agreement with my client's consent that after she was safely out of the unit, had secured a safe place to spend the night, that I would then address the issue with the housing program. And so for me, it's always giving my clients all the options. There is a real fear that, especially if you get an attorney involved at any point when you're living at a housing complex where you have a grievance with that particular housing complex, that that may escalate things and it may result in a more hostile environment for you. And again, these are people that you're relying on, that you have to see every day. For this particular person too, unfortunately, she was never able to build really strong rapport with staff. And there were actually a lot of other personal things happening with her life at that time that caused her to become really elevated. And it's unfortunate that she was never able to develop that relationship, because she would have felt far more comfortable expressing to staff what was truly going on that led to this kind of emotional outburst. And so I've notified the agency. We're working on updating their protocols. So that's kind of like how I address the issue. I find the source of funding. I ask my client directly, from the statute, or from the regulation, what does it say is required in this particular instance, and then see what matches. In this case, nothing matched, unfortunately. The other thing that I will mention as well is, and I said this in the beginning, these regulations can be very confusing. There's a lot of other things in accepting this money that you're agreeing to do as well. And so again, my approach is always to come from this is not a malicious act. This is an act of just not knowing. There are other options that I can obviously make available to my clients, which is like litigation. And that's something, that there's folks that definitely explore that, and that's always something as an attorney we can explore too. In my particular experience, I always give my client the choice to decide what is best for them in their situation. Because making somebody homeless, again, without a true opportunity to defend themselves, to consult with others, to assist them with navigating that process, means that this person will likely return to homelessness, which can be obviously a very re-traumatizing experience and can have a lot of long-lasting impact. So that's my case example in working with somebody, particularly in COC-funded housing. John, if you want to bring us to Raya.
Sure. I just want to just validate what you're saying too. It's really important to remember that these places are these service providers they're supposed to be transitioning people to a better place, not making people homeless again. So it's a really good case example. So and now I'm going to talk about Raya. It's a really important piece of legislation. So it's the largest piece of legislation that affects youth experiencing homelessness, provides millions of dollars in funding to the Family Youth Services Bureau and its grantees. So it was originally passed in 1974. It has been amended several times. It's since its enactment, and there were significant changes in 2008. And there was a final rule, federal regulation that was promulgated in 2017 that also had significant changes. So it provides federal funding to emergency shelters, transitional living programs, other housing programs, the ones we've been talking about, and it's specifically targeted to youth and young adults. So the funding provides the basis for runaway and homeless youth programs and the Family Youth Services Bureau as part of the Department of Health and Human Services. And so the Family Youth Services Bureau oversees hundreds and hundreds of grantees in almost every jurisdiction around the country. The RIA made it the responsibility of the federal government to develop an accurate reporting system on the prevalence of youth homelessness and to assist in the development of an effective system of care, including prevention of aftercare services, short-term and long-term housing outside the jurisdiction of the child welfare system and the law enforcement system, which is really important. And you can go to the next slide, Erica. And it also said the purpose of RIA and the grants program was to establish and strengthen community-based projects to provide runaway prevention, outreach, shelter, and transition services to youth who have become homeless or at risk of homeless. So again, this is to make sure young people transition out of homelessness. So the fact terminations really should not even be all that considered here, but so we're gonna get to that. But so there are two huge residential programs that they fund. You can go to the next slide, Erica. So there's these two massive residential programs. So one is called the Basic Center Program. It provides temporary shelter for minors experiencing homelessness for up to 21 days with counseling, therapeutic, and family interventions, and access to educational services. And so this is basically the emergency shelter program for minors. It's really the goal of these Basic Center programs is to reunify with families, which is not always it's not always possible. And they only have 21 days, so those 21 days can really tick. And the next program is this transitional living program. So it provides longer term housing, which can include host family homes, group homes, supervised apartments, owned or operated by the agency for transition age youth 16 to 22. Unless your state defines transition age youth at up to 24, that can happen. Some states do it, like California. But for FISBE's purpose, it's transition age youth from 16 to 22 years old. And these programs have supportive services. They also include maternity group homes for pregnant and parenting youth. So what are the due process rights under RIA? This is a really good question. So there's good news and bad news. So let's start with the bad news. There is no formal process. So like what Tori was saying, under the COC going through each element, there's nothing like that under RIA. There's no notice provisions. There's no opportunity to be heard, and does not exist in this legislation. But the good news is the language is much stronger. So the language they use is safe and appropriate exits rather than terminations. So the grantee shall ensure that youth have safe and appropriate exits when leaving the program, and each grantee shall report data on the type of exit experienced by each young person from a transitional living program or a Basic Center program. And they even go further because there were regulations that were passed in 2017 where they defined what safe and appropriate exit means, and even gave examples. So it says safe and appropriate exit means a setting that reflects the achievement of the intended purposes of the Basic Center and transitional programs. So they give examples in the reg. So it says an example of a safe and appropriate exit is to the private residence of a parent, guardian, another adult relative. So this is basically the reunification piece. To another residential program if the youth's transition to other residential program is consistent with the youth's needs. To an independent living program if it's consistent with the youth's needs and abilities. And then it defines what safe and appropriate exits are not. So safe and appropriate exits are not to the street. That would not be safe and appropriate. Or to a locked and correctional institution. So into juvenile justice or a jail is not a safe and appropriate exit. To another residential program if the youth's transition to that program is inconsistent with their needs, or to an unknown or unspecified other living situation. So each grantee is held to a standard. So the FISBE made these rules that each grantee has to be 90% effective in providing safe and appropriate exits. And these are their performance standards. That's not what the regs say. The regs say all youth should have safe and appropriate exit, but it's their way to hold them accountable. So it's a good thing, but all youth should have a safe and appropriate exit. I'm going to pass to Tori again to talk about what she's seeing on the ground.
Hello. The one thing I'll note too is that when FISBE introduced the safe and appropriate exit concept, where they said, this is what it is, this is what it is not, they received a lot of pushback because this is a pretty high standard when you're saying that, like, you have to ensure that a young person, if they're exiting your program, they are in these 3 discrete places. And so, but FISB was insistent that this was important in achieving the objectives of the RIA grant, which I would wholeheartedly agree as well. So another case example, because I've been doing this for a while, and it's still work that continues to need work in here. But so I had a particular client, again, was a pre-existing client, was in a transitional living program, and had called me, was fairly successful there, as far as I had understood, contacted us, let us know that she was being terminated from this transitional living program. Again, immediately I run to what funding is supporting this particular program, where do I need to direct my attention in terms of the regulations about what's appropriate or what needs to be done when terminating this young person. This particular program, as you might imagine, was supported with RIA funding, which I was able to get access to that information online. Her particular circumstances, I will admit, were a little bit more frustrating. So for her, it was kind of unclear why she was being terminated from the program. And again, the great thing about the COC and ESG regs is that they clearly set out that process, and providing written notice is really, really, an elemental part of that. And this is kind of like where that comes in, why that would be so important in a situation like this. So she was told one reason for being terminated, which was that she wasn't participating in all, like, the programming that was being made available to her. She was told that she could, so long as you cured and you started participating again, we'll be fine with it. And then there were still threats of termination. So then it became, you were coming in past curfew, which was 7 o'clock, which seemed very early for me for a young person, but so then she was told that there were curfew violations. So the reasons kept on shifting, and because nothing was ever clearly put in writing, it gave them the ability to kind of change the reason for why the termination was necessary in her circumstance. It then became, you came back to the transitional living program smelling like marijuana. So these explanations kept on shifting for her. Nothing had ever been put into writing. Even the date of her termination kind of was in flux as well, which made it really difficult for her to kind of figure out the urgency of, do I need housing tomorrow or do I need it in 2 weeks? Eventually, they told her, we're going to give you 3 weeks to get out, essentially. During that period of time, there were no efforts that were made by staff to rehouse this young person, despite having this requirement of a safe and appropriate exit, which is essential to ensuring the safety of young people. For this particular person, she was a minor, she was a young woman, and really RIA, one of the huge goals of RIA, or the problem that it was seeking to address, is that young people who are experiencing homelessness, who might be living on the streets, are much, much higher level of experiencing some sort of sexual violence. And so for this particular young person, no efforts were made to rehouse her, to find suitable housing, to find any of these safe and appropriate exits. Again, I gave my client the option. I am happy to reach out to this service provider right now and say, listen, these are your obligations. You need to do X, Y, and Z for this young person. She also had no interest in staying in the program. She just was interested in finding a new place. Again, she didn't want me to intervene because she was worried about it creating a more hostile environment. Already her relationship with staff had similarly kind of disintegrated at that point. Staff had ceased communicating with her. And again, there were no kind of real undertakings to find her new housing. A lot of the housing search that took place was actually by, like, our agency or by this young person herself. So eventually the day arrives where they said, you have to be out by 2 p.m. today. This is a firm termination date. You have to pack up all your stuff and get out. She sat in a company vehicle for several hours, her and her friends, on cell phones, trying to find a place where they could spend the night that night. As I'm sure with a lot of communities across the US, emergency shelter, it can be really difficult to get into. They're always at capacity. Emergency shelter wasn't an option for her. And so they were calling everyone that they knew essentially to see if they could spend the night at their home. They were finally able to, this particular client was able to spend the night at a friend's coworker's home. So this was a stranger that she did not know, who did not have her best interest in mind as far as we were concerned. And then from that point forward, she was couch surfing at stranger homes in unsafe places for the next several months. And she was 17 years old at the time, and her situation became so uncomfortable staying with various strangers that at one point she secured an overnight job so that she would have someplace safe to be at night. Now, mind you, that job required her to travel on public transportation for more than an hour at either the very late hours of night or the very early hours of the morning, which also presented a huge safety risk to her. Thankfully, nothing happens during those commutes, but it just kind of showcases the really, really dangerous situation that she found herself in because this program did not ensure, and the regulation uses the word shall, which in the legal world is like a firm word. If something says shall, it's a must. It's not a may. You're always looking for those words to determine like how strong is this right, and it is a shall there. And so she didn't want me to intervene during the time at which she was still there. As I'm sure many folks on this call know and probably experienced in their own practice, once you have a client that is becoming more and more unstable, the housing is slipping from them, they're shuffling from place to place, night to night, it's really hard to maintain consistent contact with clients. Cell phone numbers change. They have different priorities at that time. And so with this particular client, she absolutely is interested in addressing the issue after the fact, knowing that this issue is persisting with other folks. But as many of you can probably imagine, she has other priorities right now that are coming before this, which is certainly understandable. But I just hoping that that highlights that her situation post-termination was the exact situation that this was intended to prevent. It has had a long-lasting impact on her. She had a job prior to the termination. She was not able to secure any long-standing employment during that period of instability. She was also enrolled in school as well, and as you can imagine, she's fallen behind on school as well because she doesn't have a place where you don't know where you're spending the night every night or just where you're going to be during the day. It's really hard to focus on these other things. And so she's also fallen behind on school, and that used to be something that was really, really important to her. So again, kind of knowing what funding this project is being supported with can help determine where you can push agencies and find if they're doing things incorrectly or they need to improve their policies or maybe even add policies to ensure that young people aren't left on the streets and aren't exposed to even further trauma. So that's my case story for this particular person. Again, the thing I always emphasize is client choice. If they're not ready to address the problem, that is their choice. But I do always make a point to come back to my client and say, you know, in the future, I am here should you change your mind. So that's my case story for our RIA funded agency.
Thanks, Tori. I think we've heard 3 case examples today, and all of them had issues of retaliation, which is really problematic. But I think that is the power dynamic in many of these situations. And sometimes I don't think it's, it's not like an evil intent. I don't know if I'm saying the word right, but evil. It's not evil, but it's people don't know the regulations, and that's why why I've been researching this issue and why Tori's been actually very helpful to me. So, and not to put too fine a point on this, but we've been carrying out surveys around the country. You can go to the next slide, Erica. We've been carrying out surveys around youth experiencing homelessness, right? It's a pretty extensive survey. We've done it in California, Washington, Oregon, Pennsylvania, Delaware. going to try and link up with Tori to try and do some in St. Louis as well. And we've been asking all kinds of questions, but one of the questions we've asked is, have you been asked to leave or been terminated or exited from one of these housing programs? And the preliminary data we have is that almost 30% of youth say yes. And then we also follow up with questions about procedure and did they provide you a place to go afterwards? Was it a safe place? And quite frankly, the preliminary data we're getting is pretty alarming. So this is an all too common problem. And yeah, so to move on to what Corey was saying about identifying the funding, this is the exact. So we're gonna move on to some practice tips here. So identifying the funding is exactly what is the first thing you should do. And really what I think you should do is try and find out, is it RIA funded first? Because I think the language is the strongest there, and really it's the biggest. RIA is the biggest program specifically for youth and young adults. So it's a pretty easy process to do. There's Katie and Erica, we're going to put the link in the chat, but they have their own. The Family Youth Services Bureau have their own website, right? And where they list all of the grantees. So you can actually go through your state or your region and you can click on all of the grantees that are under the transitional living programs, the basic centers, or the maternity group home programs. So you can go right through that. So I actually did this for someone not long ago. We do a lot of technical assistance at the law center. So someone who they hadn't worked with youth before, not very often, and it was a former foster youth, and they were in a transitional living program, and she was just asking me, can they just kick someone out because they were in danger of being terminated? So she told me the name of the program, and I helped her look it up really quickly and told her what the regulations were around safe and appropriate exits, which hopefully helps. I haven't heard back from her, so hopefully that helps. But it's really easy to find out funding in RIA. It's not as easy for COCs and emergency solution grants programs, but if they're not funded under RIA, like say if you looked and they weren't funded under RIA, most likely there is some COC or emergency solutions grants programs, and so they would have some of those rights. So it's usually either or maybe some state funding. So and like I said, we do lots of technical assistance here. If anybody didn't know what to do or how to look up something, you can always contact me. We're going to put my name and number in the chat, and we're always looking to talk to anybody and help advocates figure out people's due process rights. So the next tip I would say is, most shelters and transitional living programs, they must be licensed by their own states. Now, this isn't true of all states, but most states license their transitional living programs, even if they're funded by federal grants. So, for example, in California, the state has licensing procedures for community care facilities. Transitional housing for minors and non-minors must be licensed under these programs, and they have their own policies and procedures. They have their own discharge and removal procedures. And they're listed under they're called congregate care facility requirements. So if you suspected someone was not following their procedures with this facility or this transitional living program was not following their procedures, you can file a complaint. You can, and they actually, on the California website actually encourages you to do so. They have a phone number. You can use the phone number, or you can use a complaint form online. And the process is that the local licensing office will make an unannounced visit within 10 days and get back to the complainant. So that's California's, right? But almost all states have these licensing requirements. And I think the easiest thing to do is to sort of, if you're questioning this, you can go onto the Attorney General's website in your own state and figure that, and sort of click around there. Or you can just call them. I did this in another state, where you just call them and find out what the licensing procedures are. And I know where I used to practice in Washington, they have their own complaint processes. Oregon has their own complaint process. I think Tori's told me about Missouri's process as well. So most states have this. So I think we're running out of time, but I'm going to keep. So something else you can do is you can file a civil rights complaint with the Department of Health and Human Services. It's an easy way so youth are experiencing, youth who experience homelessness are at elevated risks of discrimination based on disability, race, sexual orientation, youth are disproportionate of color and of the LGBT community. So if you suspect someone is being discriminated, or if you suspect you're being discriminated against, you can file a complaint in writing and name the provider who you believe is discriminated against you. It has to be done within 180 days of the incident, unless you could show good cause. But it's a really easy process. You can go right on the the Department of Health and Human Services Civil Rights Complaint Portal. And we cover this all in our practice guide, which I'm going to talk about in a second. And you can also file housing discrimination under HUD. You can file OIG complaints under HUD. So there's a lot of different ways, and we cover this in our practice guide. Just the last thing I would say is maybe the most important, but we're in the preliminary stages, is that filing a lawsuit or a private right of action, we believe is something that should be happening relatively soon. So based on the 2008 changes, but to the Runaway and Homeless Youth Act and in the final rule promulgated in 2017, actually Tori did a really good job of explaining that. We believe that there's a property interest in a youth's right to their own shelter. So the non-discriminatory language they included and the language around safe and appropriate act is really, it gives a strong indication that they have their own property interest. So, and so you can go to the next slide. So this is all covered in our practice guide. It's the last part of our practice guide. This is all these tips that we have. But so the last day, I just wanted to make many youth advocates don't know that these rights exist. Like I did not know that these rights exist when I was practicing, and I represented my client Aaliyah. So this is why we wrote this practice guide, to reference these rights and create awareness around them, that so we can begin exercising them, just like Tori was talking about. So it's really, this is an awareness and creating awareness around these rights, so we can start exercising them. And just like I said, all the practice tips are included in detail, as well as exhaustive research on RIA and the Hearth Act. We're really proud of this. We worked really hard. Erica made it pop with her design, and it's linkable. There's tons of links in there around the regulations and the procedures and the safeguards. So you can link through them. And shout out to Erica and Katie, who I think Katie read this like 5 different times. I think we're going to put a link in there. You can get it, you can download it from our website. So I'm going to pass it to Erica to talk about the next webinar that we have.
We're actually going to pass that to Katie, and I'll go to the next slide.
Oh, sorry.
Awesome. Thank you so much, John and Tori, for this excellent presentation. I do see that we have one attendee with their hand raised, and I don't know if we're able to unmute them to ask a quick question. Oh, I think the hand raise went away. So anyway, if anyone has questions, I did put John's contact information in the chat. We'll send a really thorough email out after this presentation with the links to everything, everything that you saw in the chat. But I do want to highlight our next upcoming webinar and some really important information about the Homeless Youth Legal Network. So this is a sort of directory of legal services organizations that work with youth and young adults experiencing homelessness. I'm putting a link in the chat for folks that if your organization, if you work for a legal aid organization and you're not already included in this directory, or if you are a service provider that refers youth to legal services, I'm gonna just include this link here so that you can find out if your organization is already included. And if it's not, there's a way for you to request your organization to be added. This is a really important resource for young people who are trying to enforce their rights. And then finally, we want to let you know about our next webinar, which is going to be about accessing legal services and changing laws to end youth homelessness. We have some excellent speakers who are going to, including a young person who's going to talk about their experiences of sort of working with holistic legal services to help them become housed, and then also how they got involved in advocacy effort to change unfair laws. And then we're also going to hear from some other folks who will just talk a little bit about how we can sort of increase the ability for youth to access legal services and get involved in advocacy efforts. We have 2 time options for this webinar. I'm putting the registration links in the chat. And I think with that, that is all we have for today. Thank you again to our wonderful panelists. Thank you all for attending. Oh, and thank you, Kelly, for putting the your contact information in the chat. We're really looking forward to sort of increasing the resources that we are able to provide for youth when it comes to enforcing their legal rights. All right, thank you all. Have a wonderful afternoon.
Thank you, everyone.